As service members from Iowa continue to train and deploy for military service around the globe, their employment rights are being protected here on the home front. Federal law provides protection for these service members. However, it is up to the individual service member and their employer to know their specific rights as they pertain to a service member's activation, their deployment, and their return to civilian employment.
The employment and reemployment rights of service members and veterans are protected by federal statute. The statute is commonly referred to as Userra, which stands for Uniformed Services Employment and Reemployment Rights Act. Congress passed this law to encourage non-career service in the military, minimize the disruption to employers and employees that results from deployment, and prohibit discrimination against service members. Userra protects service members from workplace discrimination and/or retaliation based on the service member's affiliation or military service. Userra also requires employers to place individual service members and veterans back to work in their civilian jobs after their military service is complete. In other words, employers cannot hold an employee's service against the employee.
It's important to remember Userra applies to all public and private employers in the United States, regardless of the size. These employers are prohibited from either discriminating or retaliating against a service member. An example of such discrimination would be denying an individual a job based solely on the possibility that individual might be deployed in the future. When it comes to reemployment, an employer cannot take any adverse employment action against the service member because the individual has exercised his or her rights under Userra.
If you or someone you know is experiencing an employment problem related to his or her service, the Employer Support of the Guard and Reserve, or ESGR, provides an invaluable resource. The ESGR website at www.esgr.org should be used as a reference for any questions dealing with the employment rights of Guard and Reserve members. This video is meant as an introduction to the law and the services available to help understand Userra.
Userra is very specific as to the rights afforded to service members based on the amount of time absent from employment. Typically, service members are entitled to the position they would have had were it not for their military duty. The ESGR website or the Act itself will provide additional information on the rights of the employer as well as the service member.
When taking an action to enforce Userra's protection against retaliation and discrimination, the burden of proving the violation rests on the shoulders of the service member. In order to carry that burden, the service member must show one of the following: membership or application for membership in a uniformed service, performance of service, application for service, or obligation for service in the military, action taken to enforce a protection afforded any person under Userra, testimony or statement made in or in connection with a Userra proceeding, assistance or participation in a Userra investigation, or the exercise of a right provided for by Userra. Once the service member establishes proof of one of the above, the burden is then shifted to the employer, who must prove that the adverse action against the service member would have taken place regardless of the member's service.
Userra does create certain exceptions for employers. One such exception exists when the employer can establish that its circumstances have changed so much that reemployment would be impossible or unreasonable. For example, when there has been a reduction in the employer's workforce and the reduction would have included the service member if the individual was not absent for purposes of uniformed service. Employers need to treat returning service members the same as they would any other employee in that reduction or with a similar type of leave, for example, FMLA or jury duty. In the case where returning service members are disabled and unable to perform the duties of the position, employers are required to find a position within their companies that service member can perform. The exception is if there are no positions available, employers do not have to create a job for them. However, there are no cost equipment and educational resources available for the disabled service member, so the employer can place them in an adequate position.
An individual has three options when he or she believes that his or her rights have been violated under Userra. Contact Employer Support of the Guard and Reserve, or ESGR, which will attempt to resolve the potential issue fairly between the individual and the employer. File a complaint through the Department of Labor Veterans Employment and Training Service, or DOLVETS, or proceed to civilian litigation. These options are not mutually exclusive, and individuals are urged to utilize both ESGR and DOLVETS prior to filing suit.
If the individual files a complaint with DOLVETS, it may be filed either in writing or electronically using VETS Form 1010. The form is available through the Department of Labor website at dol.gov. The complaint must include the name and address of the employer, a summary of the basis for the complaint, and a request for relief. The U.S. Secretary of Labor, through VETS, provides assistance to both employers and service members. The assistance provided by VETS includes a wide range of compliance assistance outreach activities and can be accessed through the Department of Labor website at dol.gov. Additionally, and as previously mentioned, ESGR provides information and assistance to both service members and employers. Both resources should be used and accessed whenever a question arises as to the rights afforded under Userra.
The body of law that makes up Userra is vast, and for that reason, this video is meant only as a tool to inform you of the existence of said law and to provide assistance in locating other, more specific resources on the topic of Userra.
Remember, the ESGR website and the other organizations are ready to assist you with Userra when you need it.
Through the use of these resources, it should always be remembered that Userra is intended to not only protect the employer-employee relationship, but to ensure that service members who have sacrificed for this nation are afforded all the rights they have worked so hard to preserve and defend.